Good morning and welcome to our commission meeting today, April 13th, 2023 at 10:09 a.m. at the Washington State Gambling Commission. We are in person and virtual. This commission meeting was originally scheduled to be over 2 days. However, we're going to try to finish it in 1 day, but we will be ending at 3:30 this afternoon. If there's anything left in the morning, it will be over virtual over Teams. So we'll know if we're going to need tomorrow at the end of today. If you have any questions regarding the meeting, please contact Julie Anderson at julie.anderson@wsgc.wa.gov. Telephone lines are currently muted. When I ask for public comment, raise your hand and the staff will unmute your line. You can then provide your comment and remute your phone. When you comment, please clearly state your name, your contact information if you'd like to receive a summary of all comments and who you are representing. Today's meeting will be recorded, and today we also have a new commissioner who was appointed yesterday, Commissioner Anders Ibsen. So I'm going to allow him just a couple minutes to introduce himself.
Thank you, Chair, and really nice to see everyone here today. Just wanted to say thank you so much for the opportunity. My name is Anders Ibsen. I'm from Tacoma. A little bit about me. I have a local government background. Prior to doing this, I served on the Tacoma City Council for 8 years, and prior to that, for 3 years on the Pierce County Conservation District Board. Besides various nonprofit activities, my day job is in real estate. I'm the managing broker of a team in Tacoma, and I'm also a home appraiser too. So this just seems like a great way to serve. I love administrative local government stuff, and in this case, state government stuff. And very much looking forward to getting started, working with all of you and getting educated too. So thank you very much for the opportunity. Looking forward to working with you and getting to know all of you.
Great, thank you. Welcome to the commission. So now we have all the commissioners in the room. Vice Chair Julia Patterson, Commissioner Sizemore, Commissioner Lawson, Commissioner Ibsen. Do we have Senator Conway? Senator Holy? Representative Klova? Or Representative Rude? No, it does not appear.
Maybe they're voting today.
Oh.
I think they're on the floor today.
So we are going to start with the petition for review, which is the Shan Malati Touch case number CR 2021-01221. First, we have a motion to strike that was carried over from last month. So we'll do that first, and then we'll go into closed session. And then after the motion to strike, we could go into the petition for review piece. So do I have Mr. Frank Hugenin? I'm sorry.
It's quite all right, Madam Commissioner. It's Frank Hugenin, and also is my co-counsel Jeff Carl.
Great. So those are the attorneys for the petitioner, and we have Doug Vanderbrake, the Assistant Attorney General for the commission. So we will go ahead and give each side 10 minutes solely on the motion to strike. So we will start with the attorneys for the petitioner, and I will set a timer. And
Chair, this was
Your
actually
Honor?
the state's motion to start with the motion to strike. So yes.
I'm sorry. Okay. So we'll start with Attorney General Vanderbrake for the motion to strike piece first. And for this one,
thank you, commissioners. My name is Doug Vanderbrake. I'm an Assistant Attorney General representing the Gambling Commission staff. The basis for this motion to strike is that when Mrs. Touch filed a petition for review, she included 2 exhibits, exhibits A and B, but exhibit B included 16 subparts, effectively 18 exhibits. The problem is none of these exhibits were ever offered, admitted, filed, or served as part of the administrative evidentiary hearing in this matter. Mrs. Touch had ample opportunity, and she is represented by former counsel to file exhibits. She did not do so. She then requested an extension of time to this case schedule and more time to file exhibits. The administrative law judge granted Mrs. Touch additional time to file exhibits, Yet, even with that, she still did not do so. The proceeding then proceeded to the administrative evidentiary hearing, which ultimately spanned 9 days over the course of many months. And not once throughout those 9 days did Mrs. Touch ever file, serve, or seek to offer to admit any exhibit for this case. Now, we're here to review the initial order issued by the administrative law judge following that hearing. And as the reviewing officers, the commission should be reviewing the record that was created as part of that hearing, not new information that Mrs. Touch now wants to get into the record. The review of the decision should be confined to the record. And for that reason, those exhibits should be stricken and not be considered by the commission in the course of its review of the underlying petition for review filed by Mrs. Touch. Now, this case, it's governed by the Administrative Procedures Act, and it's fairly well established that under the Administrative Procedures Act, the reviewing officers, the review does not provide the reviewing officer to go outside of the record to take additional evidence. Furthermore, the commission's own hearing rules specify that its review of initial orders are based on RCW 3405464, which is the APA provision governing review of initial orders. Also, the commission's hearing rules, Washington Administrative Code 230-17-090, states that petitions, referring to petitions for review, must specify the portions of the initial order the parties disagree with and refer to the evidence in the record on which they rely to support their petition. Those 18 exhibits Mrs. Touch is now trying to get into the record are not part of the record for review and accordingly should be stricken. Commission staff respectfully request that the commission grant the motion to strike and exclude those 18 exhibits that Mrs. Touch is trying to now get into the record. Thank you.
Thank you. You can go ahead.
Oh, thank you, Madam Commissioner. I think it's important for this commission to understand the disparity that exists here, and in particular, the process and the tactics that are taken by the WSGC staff and its counsel related to these evidentiary hearings. Now, yesterday, as you guys may already be aware, I represent Sofa Fall Chan in the sister case. She was the dealer in the alleged overpayment. And we got discovery served yesterday, responses, I should say. And the WSGC staff and its counsel is of the position that they don't have to provide any sort of fact witnesses information regarding the allegations that they're making. And the fact witnesses in this case were Mr. Stroud and Mr. Martin. So their position is that they don't have to disclose any witnesses that they plan to call or any factual underpinnings of those individuals until after the discovery cutoff has occurred and when they have to do their disclosure of witnesses. The problem with that is that by not disclosing that information, there is no way for then a licensee to do any sort of due diligence, any sort of discovery, any sort of investigation into the credibility of the very witnesses that the state relies on. And therein lies the rub. We presented this information so that the commission can exercise its larger duty to ensure that those operating under its authority are doing so in good faith and are not abusing the powers bestowed upon them. In this situation here, there would have been no way for Ms. Touch to be able to do any sort of investigation based on the Gambling Commission staff's position that they have no duty to identify who it is they're going to be relying on to establish the facts that they're alleging. And so that's the reasons why it's provided. As far as the specific exhibits, Exhibit A is nothing more than an illustration to allow for the reader to understand essentially the disparity on the alleged overpayments between what was asserted in the notice of administrative charges, which does list two different amounts. And to the extent that that's been explained by Mr. Vanderbrake in his reply material, we're satisfied with that. It is a disparity, though, that I think is worth addressing down the line. But as far as the Exhibit B and the discrete subparts, we're presenting those to you so that Ms. Touch can actually have a first opportunity to attack and to challenge the credibility of the very core witnesses that the state has relied on in this matter. The fact that so I do a lot of civil litigation, and in civil litigation, the disclosure of possible primary witnesses happens before the discovery cutoff. That gives the parties an opportunity here to be able to take steps, investigative steps, to then go ahead and build their case and challenge any sort of credibility of the witnesses that are being relied on. But if you look at this matter here, that's not the case. The discovery cutoff happens before this disclosure, and Mr. Vanderbrake seems content to feel that, and that'll be dealt with separately, but he seems content to feel that the Gambling Commission staff has no duty to provide any information, thereby curtailing any due process right of Ms. Touch or any other licensee for that matter to be able to actually get to the truth of the matter and to be able to actually investigate the veracity of the claims being made. And so for that reason, with the understanding that this commission has a considerable amount of power and discretion afforded to it under the statutes, we would request that these exhibits remain and that Ms. Touch actually get a meaningful opportunity to challenge the credibility of those making accusations against her. Thank you.
Thank you. And Mr. Vanderbrake, you have about 6 minutes left if you.
Yes, rebuttal, please. Thank you. My opponent's argument is without merit such that it almost doesn't even merit any response. But I can't let it slide. I'm pointing out that it's a misstatement of law. A party during discovery is not required to disclose the witnesses it's going to name in its case. That is done and can be done when a party files its witness and exhibit list. Now, germane to this case, Mrs. Touch's attorney had full and ample opportunity to serve discovery, and he did not do so. Why did he not? I can only speculate, but I can say that he was provided with informal discovery and that he was provided with the case report and the case attachments on which the investigation was based and from which the notice of administrative charges derived. And he received our witness and exhibit list. Despite that, and despite not filing their own witness and exhibit list and getting an extension to do so, they still did not file any exhibits. They had every opportunity to do this multiple times prior to the hearing, with extensions prior to the hearing, with getting continued dates to the hearing, and over 9 days of the hearing. At any time, they could have offered any exhibit they wanted to for the record, okay? But they did not. It's too late for them now to try to, because they're dissatisfied with the result, or Mrs. Touch's new attorneys might have tried the case differently, or they think there are exhibits that might have helped her that were not offered or admitted ever by her. Now is not the time to now seek to bring in new information, right? Now to try to find exhibits that were never part of the record. They were never part of the record, and therefore they form no basis whatsoever for the administrative law judge's order, right? The trier of fact who heard the exhibits and the testimony of the witnesses, okay? And that's what should be reviewed, that initial order, not to now go outside of the record and consider these 18 exhibits. Again, we respectfully request the motion to strike be granted, the 18 exhibits be excluded. Thank you.
Great, thank you both. Now we will go into closed session. We will discuss this with our Attorney General.
You're gonna say-
leaving or you-
We're leaving.
Okay.